Manever I say ma Pen Dream TV. Pen Dream TV there, I see them yopo.
You are once again welcome to Pen Dream TV, the only channel that brings you the best and latest updates in politics. If you are new here, please don't forget to subscribe to the channel, hit the notification bell for more updates, like and also share to other members to watch as well. You can equally leave a comment after watching or send us a voice note on our WhatsApp number, which is 0277 128 777. Thank you. I want you to join me listening to what we have for you today. Is all about how Godfrey Dame behaved in the Supreme Court, which Edwigi has also reacted to his behavior, saying if Ghana were to be any serious country, like Dame will never be Attorney General. Without much ado, I'd like you to join me listening to what he said into detail. Thank you.
And also with me on the show this morning is the Director of Legal Affairs of the NDC. Okay, and in the last 24 hours, his accolades have gone up a few notches, and his acquisition of FTs is also gone up by a few hundreds.
Don't allow Ferguson to influence you negatively.
His gang of four are also seriously working for him.
Yeah, God. We are working for Mahama.
He's here with me on the show.
Randy, good morning. And good morning to my learned friend. And good morning to your viewers. Yes, Randy.
Okay. So what has led to the accolades in the last 24 hours from the Western region to Accra and the donation of more FTs?
Okay. I deny. Yes, and it's good that way. So,
you don't know what FTs are. You don't know what FTs are.
It's FT. I thought Financial Times.
Oh, okay.
That's what it is.
He says it's a Franklin template. Oh, okay. There are some who also says it's a.
It's okay. We'll move forward. So, Randy, as you are aware, we did our internal primaries somewhere 13th of May 2023, and thereafter, I think about a year or so later, some party members took the party to court at the Secondary High Court on the eligibility issues of the candidate that won in Amenfi Central. And we went to court. The court granted an injunction restraining the candidate. Subsequently, we decided to annul the said election and to rerun it. And we opened the avenue for everybody to come and contest again. After that, on the 9th of September, we presented our candidate to the Electoral Commission on the basis of the rerun election. The Electoral Commission actually came to supervise the rerun. And thereafter, we presented the candidate on the 9th. On the 10th of October, the EC now writes to us, indicating that the candidate had been disqualified on the basis of the injunction that was granted in May. So first we went to the High Court in Accra to challenge the disqualification dated the 10th of October and apply for some interlocutory reliefs, injunction of course. The High Court said no, they won't grant the injunction, so we should go back to Second D. So immediately after court that day, I think we left court around 10 a.m. I moved straight to chambers with my colleagues. We put together the application to vacate the interlocutory process and got it filed that same day. We scanned the processes with an agent there. We did everything and served the Electoral Commission because we had a relief B in it to restrain them from printing the notice of poll and the ballot papers. And then the substantive relief A had to do the vacation of the injunction order. So yesterday, finally, the application was taken So I moved the application to vacate the injunction order.
But also, just so I don't, I don't interrupt your flow, but was there any interim order that was denied you by the secondary court after the Accra one?
No.
Okay. There was no order on the EC. There was no order to prevent the EC from going ahead with the printing, which was denied.
Which is the Accra one?
That was the Accra one.
That's the Accra one. So when the 10th October letter came, we issued a writ, and then we applied for an injunction. So the Accra one says no, they will not do it. In a very interesting circumstance, they will not do it. So quickly that day, knowing that once the order is taken, the EC will just go ahead. That same day, I had to do this application to vacate, and then the relief B asked that the EC is restrained. So it was in the relief B in this new motion. So when I did that, and we got everything filed in the Secondary High Court, the court gave us the 7th of November to move the application. But we ensured that the EC regional office in Western Region were duly served with the application. That will keep them in check in going ahead with the printing of the notice of poll. Good. So thankfully, when we went on the 7th, the plaintiffs, respondent now, asked that they be given time to file all the necessary processes. And the court said, no, we should come back. In fact, they said we should come back on that's yesterday. So we went yesterday, we moved the application. First, there was an application to dismiss the entire suit, which the court said no. So then we had to move the application to vacate the injunction order, which was taken, and the court gave a bench ruling. In this wisdom, felt that we have demonstrated.
What is the bench ruling?
You know, usually the court can go and say, look, we'll come back with a ruling. But the bench ruling is right there.
Okay.
The judge is seated.
Jinaoji.
Yes.
Shishishi.
yes, right there. Okay. So that's basically what happened yesterday. The court gave a bench ruling. So immediately I have to get the Electoral Commission informed because they had a rep in court.
Okay.
And so he heard what the orders were. But again, we needed to formally communicate. So because of the inter-party engagement, I triggered that process. And the Electoral Commission said, okay, yes, if that's the case, we should serve them with the order itself. So I had to stay back yesterday until almost 5 p.m. to see if I'll get the order. It has been drawn. But, you know, my Lord has to ensure that it reflects, the person typing is different from, just to ensure that everything that is captured in the ruling is captured in the order that will be drawn. So we should be serving the Electoral Commission today so they can have her on the notice of poll.
Okay. All right. Let me hear you on the two issues.
Yes, Randy, before I even start, today happens to be the 4th anniversary, the wreath laying ceremony that our party is having in relation to the passing of our former founder and former president, Jerry Rawlings.
Your founder?
Yes, our founder. So we are doing that today at the party headquarters from 10 a.m.
Oh, okay. So that's in about 25 minutes.
Yes. Now, Randy, having said that, I think...
It's 4 years already.
Yes, 4. November 2020. Randy, I want to possibly handle this issue this way. First of all, the comment by Godfred Yeboah-Dame in the court yesterday, I find it extremely bizarre.
Why?
His concerns. You see, much earlier, after the court proceeding, Mr. Godfred Yeboah-Dame introduced something into the conversation that Thaddeus Sory, who had been retained by the Speaker as his lawyer and his law firm, did not have the necessary approval from the PPA, and for that matter, lacked the standing to represent the Speaker, and even proceeded that by reason of the constitutional provisions, Article 88, he, Yeboah Dame, the Attorney General, should be the one representing the Speaker. These 2 points were made by him. What he didn't also tell us is that, you see, the Supreme Court has already, in the case of Janet Amegashe versus the Attorney General, raised the same constitutional point and said, look, yes, it's true, the Attorney General has some powers under Article 88 to represent the government. However, imagine the Attorney General being the one representing the judiciary. It has the potential of undermining and compromising the independence of the judiciary. And so the Supreme Court, speaking through His Lordship Justice Databa, provided a guideline, a roadmap of what to do in those circumstances. And Godfrey Yeboah Dame is aware. But you see, consistent with his practice is always to play to the gallery, either to incite the court against a fellow lawyer, which he had done consistently. In fact, I have been at the receiving end of that conduct. I recall vividly in 2016, myself and my senior Judge Lowe had represented the Muntie 2, the Muntie 3, but we represented 2, Akugan and Alista. We were doing our private matter. We went to court one day. I was representing Alhaji Grusa and he represented Vincent Odoche before the late Justice Yeboah. Immediately we announced ourselves as lawyers. He started, oh my Lord, do you know that Eduji was the lawyer for the Muntie 3? Effectively to incite the courts against me. And thankfully the judge saw the diabolics and quickly remarked that, oh, even whilst he was in private practice, because of his inclination to human rights issues, he had to even represent somebody who was accused of murder when nobody was willing to represent. So he sees nothing wrong with it. And so that is the character and make. And so I wasn't surprised yesterday when once again he decided to make fetish out of the absence of Mr. Sori in court. In any case, what the rules of the court requires is that the party is duly notified of judicial proceedings. The person can elect not to come. And so, for Mr. Dame to infer disrespect from that conduct, again tells you his conduct, which is obviously unbecoming, in trying to, as the leader of the bar, in trying to incite the court, the judiciary, against other lawyers. And I think that 4 years into the office, he should have grown into the office. Look, I mean, this is an office that the likes of Geoffrey Bing, Swansea, in fact, his own boss, Nana Dankwa Akufo-Addo, Papa Uso and Koma, Ayuko Otu and Co., Marietta and Co., once occupied. And they brought so much honor and dignity to that office. I mean, for the record, this is the only Attorney General who, in living memory, had been caught on tape directly manipulating judicial processes. In any serious country, he should not be holding himself as the Attorney General of the Republic. In fact, the last bar conference in Kumasi, the bar council was divided because there were people in the bar council who said, look, this young man should not be permitted to come and address the bar. Really? Yes. In fact, the people who defended him were Samuel Kujetu and Co. They were spirited that he should apologize to the bar. If not, he will not be permitted to address the bar in Kumasi.
Really?
Yes. Yes. Because I spoke to members of the bar council. The bar council was divided because of the misconduct coming from him. And he has this, I don't know, this is a man who was coaching Jakpa. And he has the effrontery. And I've always said, persons whose palm kernels have been cracked for them by benevolent spirits must learn humility and not be parading around like peacocks. What is that? Randy, that said, you see, if you look at the Mo Ibrahim reports, first of all, like you rightly indicated, you are a beneficiary of the Mo Ibrahim platform.
Okay, so the Supreme Court has ruled. There's a 5-2 in favor of Afenyo. I'm told that Justices Stanko and Lovelace dissented.
Case closed.
Yes.
Okay. I hope
I love to read dissent.
Yes.
And because you raised the issue of dissent, Randy, I just want to read a very classic dissenting view by Justice Lord Atkins in the famous case of Liversidge versus Addison.
Okay.
And this is what Justice or Lord Atkins had to say.
It's an interesting case. Read it.
It's a very interesting.
Read it.
It's a groundbreaking.
He was a liberal.
And that is what he said.
Yeah.
I view with apprehension the attitude of judges who, on a mere question of construction, when faced with claims involving the liberty of the subject, show themselves more executive-minded than the executive. They show themselves more executive-minded than even the executive. You see, Randy, we are building a constitutional democracy. A democracy that we are hopeful and confident will live.
So interestingly, the panel had the original 5.
So the original 5,
The 5
I
that
think
sat-
all went well, on the
5 that
injunction.
sat on the injunction. And then the other 2.
No, they stay.
They stay. So the other 2, the 2 were Justices Stanko and
So they dissented.
Lovelace. So the 2 were added were those who dissented. The 5 who ruled in favor of the stay all ruled for Afenyo.
But let's not read things to it. I mean, we are just...
Once they'll go to conference
Yes.
and have conference. So usually you won't even get a judgment now immediately. It may take maybe a week or a few days to get it. But you see, I was on the Mo Ibrahim conversation when you introduced the breaking news. You see, when I first saw the Mo Ibrahim report on Ghana, first of all, it's a very credible platform, devoid of the NPP NDC conversation. So when I saw it, I was apprehensive. Because for a long time, if you monitor the Afrobarometer report on the workings of the courts, the reasoning and what Ghanaians have generally said about the court had always provided a cause for concern. For me, the height of it was when the National Security Minister, the Honorable Kandapara, a person who had had considerable working experience with Ghanaian institutions, had cause to tell the court or the judges in their face that when a particular consistent outcome is churned by the court, it has the potential of undermining one critical thing that is required in a democracy, public confidence. In fact, Randy, the only way you and I will have a dispute and would approach the court is that we believe at the end of the day we will abide by the outcome. But the very moment our confidence in the system of adjudication is compromised or undermined in any way, the next will be that we'll be resorting to self-help. And that self-help mechanism is a recipe for chaos. When I saw this Mo Ibrahim report, in fact, I even said, there should be an emergency judicial council meeting, at least to consider this urgent matter. Because you see, it goes to the very core of justice delivery. When an international organization, and remember, business people, when they want to invest in Ghana, what they do is to look out for such polls, to look out for such views from credible institutions. Now, if you're a business person and you are coming into the country, and you read from Mo Ibrahim or his report that the impartiality of the judicial system had moved from a record high by not a 1 percentage point, not 10 percentage point, not 20 percentage point, but 30 percentage point from 2017 to date, that should be worrying for everybody. In fact, if you practice from our court, if you're a judge and you are not worried by the Mo Ibrahim Index, its report on Ghana, then there is a problem. For us as lawyers, because we represent foreign clients, when they come, they'll ask you, do this due diligence for me, do A, B, C, D. If they are coming with a perception that our court is less, when it comes to partiality, it goes to the very core. And it even undermines inflow of investment. Because for a foreign investor, there's always a potential that you may have an issue.
In fact, even some of the recent cases at international arbitration,
yes,
that have traveled through our courts,
yeah,
even fortifies this position. The rulings of our courts on some of these cases that eventually ended up at arbitration, and the result from arbitration even fortifies and reinforces this point that you are making.
Randy, so like I'm making the point to you, if you have an investor and he wants to come and invest in this country, and he has any occasion to examine this report, question that we need to be asking is, how confident will that investor have in approaching any of our courts? That, for me, should be a great concern for all practitioners. It has nothing to do with MPP, NDC. My learned friend tried introducing that, it is because the NDC appears to talk down on the court system, and that is what has influenced the Mo Ibrahim Index. With the greatest respect, I mean, these international organizations appreciate the internal political dynamics. And so they appreciate what is called a bias in coming out with these indexes. If the conversation is only about NDC, they may think that, no, this is politics. But they have been speaking to investors. And those investors, what is the level of confidence that they have in how we adjudicate matters, especially matters involving the government? Randy, I'll give you a classic example. If you recall, there is this company called Imperial Heritage.
Yes.
Imperial Heritage, the business people, they have obtained a judgment from a court. Now listen, this is a judgment that was obtained when evidence was taken. Evidence was taken. And the judge, after everything, evaluated the evidence and on merit ruled against the Republic. If the Republic has any misgiving, you appeal it. In a very extraordinary and novel manner, the Attorney General filed an application to set aside the judgment. One, that the filing fee or whatever that was paid did not commensurate with the claims, and some other issues. And the judge agreed. And on the basis of an application, set aside the judgment that he did upon review of the evidence. I mean, when you do things like this, you get an outcome. But you will be sending a different message across. Randy, so I am worried. Look, when H.E. John Dramani Mahama presented the election petition in 2020 to the court, one, when the defense was filed, the MPP, their first ground was that the petition should be dismissed because it discloses no cause of action. That was refused. So already the court acknowledged that the writ disclosed a cause of action. So you cannot sit here and say John Mahama presented something to court that was, if not, they won't put, when your people ask that the matter be dismissed because it did not disclose a cause of action, the court would have dismissed it. The mere fact that the court agreed and adjudicated evidence was taken is that the court found that there was the basis for coming to court. I have always maintained that we lost a glorious opportunity in refusing or disallowing the Electoral Commission chairperson to testify. Election adjudication is not a mere contractual rate that you come to court with. It is at the core of mandates. It's at the core of people's ability to determine through the ballot board who leads them. But we treated it as the usual contract, and A, B, C, D, and Madame will not, and this is, and it ended it. People are watching. And always remember that the people who are watching are equally sane and intelligent and are picking this. You see, where the impression is being created that anything that makes Akufo-Addo comfortable, the court will either delay it. That thing is fueling a very dangerous perception out there. That Akufo-Addo must be made to feel comfortable, pampered. It's a perception that is dangerous. And you see, Randy, why do I make this point? Immediately, MPs passed the LGBTQ law, the bill. The Constitution provides the mechanism if the president strongly feels that there are constitutional issues, the mode that he must go. That was ignored. And we saw the cease and desist letter from Mr. Bediatuo. If you recall, the president started raising issues about the bill when he met the diplomat at the time when there was no injunction application from Richard Delasky. How did the president know that Richard Delasky was going to go to court the next day? Because at the time when Mr. Akufo-Addo was speaking to the diplomats, there was no injunction application. How did he know? Was he the one who sponsored Richard Delasky to go to court?
Richard is not an MPP, by the way. I know him very well. He's a good friend. And I did my post call with him.
Okay.
In fact, he opposes MPP quite a lot.
Okay.
So I know Richard for sure.
I didn't say he's an MPP.
No,
I
I'm
said
just trying
sponsor.
to say that he's not.
No, sponsorship is different.
Well, I read.
That's why I choose my word carefully.
Yes.
I am saying that when Mr. Akufo-Addo met the diplomats, was there any injunction when he was talking to the diplomats?
I don't know this.
How did you know that the next day Richard Delasky was going to court for an injunction? Was he briefed by someone? So you see, you people should not have the inclination that the people you are in the arena with, excuse my language, adapt. We see what is going on, and we appreciate what is going on.
They are not like me.
But you see, Randy, my friend, and again, look, Dom Levo. At the time the court eventually determined the matter, it had become Pyrrhic victory for Dom Levo. When citizens of the Republic, at the end of this kind of justice, it fueled the Mo Ibrahim report.
Okay.
Because you see, look at the speed, the alacrity with which this Afenyo-Markin matter had been determined. The same speed relative to Dom Levo. Look at when the president came out with the Imposition of Restriction Act, one of the EIs, and my own professor of international law, Professor Tia, went to the court to challenge the constitutionality of those EIs, among other things. By the time the court gave its verdict,
too late.
There was nothing useful to do with that verdict.
Yeah.
Now, so when these things happen consistently, and the impression is created that Akufo-Addo is being pampered, that anything that makes him uncomfortable is either kept on the banner. How do you expect Domelevo? How do you expect that plaintiff to feel? Is there a different set of laws for Afenyo-Markin? Where there is a different set of law for other citizens of the Republic, it's painful. And that is why I have always maintained that we all do have collective responsibility in making the court system work. Now, on this first issue, this morning, my learned friend took us into...
Makojo Boafo says that with all you said about the judiciary and the Mo Ibrahim Index, you won your case in High Court in Secondary yesterday. What do you say about that?
No, hold on. Let me. You see, what he had not said, whoever, Makojo Boafo, sorry, what he had not denied is all the instances I've given. Was it the case that when Domelevo approached...
No, he's not...
I'm coming there. That I'll respond to him.
Yes.
When Domelevo went to the court, what happened? When the president was challenged on the EI, what happened? Are they not are they in doubt?
E-levy, the MPs.
E-levy.
I mean,
all those matters.
The Supreme Court says that they're asking the GRA to keep records, proper records.
You see,
so that if tomorrow the case overturned, GRA will be able to calculate all E-levy I've paid and return them back to me.
The person who sent this text would want to gaslight us and make us feel we are rather the problem and not where the problem is coming from.
I'm sure he's
Thank you for staying tuned. Pen Dream TV is most grateful to you for being part of our channel. If you have not yet subscribed as a new member as well, please do so for us. Hit the notification bell, like and also share to other members to watch as well. Thank you. Stay tuned for more.
Pen Dream TV now, so far so good. Say open online portal e wo Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, Pen Dream TV.